Thank you. You can be seated. And could we hold just a second, please? Hold. So, folks, we're going to get started. I know emotions are running very high in this case. If you feel like you need to step out of the courtroom, please do. I'll expect everybody to conduct themselves in an orderly fashion, despite some of the allegations you're about to hear. If you feel that it's too much for you to hear, please step outside. Also, audio and visual are not allowed here via a Supreme Court order. We have one camera that's a pool camera, so that's all that we're doing here today. So please refrain from recording or videotaping this. So with that, if we could proceed. This is case number 21 CF 1848, State of Wisconsin versus Darrell Brooks. Matters tabbed to Judge Lau. Appearance by the state, please.
Good afternoon, Commissioner Sue Opper and Leslie Basie appearing for the State of Wisconsin.
Thank you. And for Mr. Brooks.
Darrell Brooks appears in person in custody with attorneys Anna Keyes and Jeremy Perry. Good afternoon.
Good afternoon to you. And we are here on a criminal complaint that's now been filed. Mr. Perry, will Mr. Brooks acknowledge that he has received a copy of that complaint, and will he waive its reading in open court here today?
We have received copies of the criminal complaint. We waive formal reading.
Thank you. It may at some point be relevant, but the address on the complaint is accurate.
That's right.
Thank you. And Mr. Brooks, I have reviewed a copy of this criminal complaint. I will find it does state probable cause as to each of the 5 charges before you. You're charged in count 1 with first-degree intentional homicide. That's a Class A felony, and that has a maximum possible penalty of being sentenced to imprisonment for life. That's for victim A. Count 2, first-degree intentional homicide regarding victim B, is a Class A felony. Again, the maximum possible sentence is a sentence to imprisonment for life. Count 3, first-degree intentional homicide regarding victim C, is again a Class A felony, and that's punishable by a sentence to imprisonment for life. Count 4, first-degree intentional homicide regarding victim D, again is a Class A felony, and that's punishable by a sentence to imprisonment for life. Lastly, count 5, first-degree intentional homicide regarding victim E, is a Class A felony. That is punishable by a sentence to imprisonment for life. As those are felonies, you're entitled to have counsel. You're entitled to have also a preliminary hearing. And I, again, have found probable cause to each of the 5 counts upon my review of the pleading. So we will turn to Attorney Opper for her bail recommendation.
Thank you, sir. As to bail recommendation, Your Honor, I'd like the court to be aware of a prior criminal history as it relates to Mr. Brooks. I can advise the court he has arrest record from 3 states to include Wisconsin, Nevada, and Georgia. Starting with the state of Wisconsin, the record begins in 2000. There was a conviction in that year for substantial battery, party to a crime. A prison sentence was imposed but stayed for 3 years probation and 6 months condition time. 2002, conviction for possession of marijuana as a repeat offender, sentenced to 50 days in the House of Correction. 2003, misdemeanor conviction for resisting obstructing, sentenced to 20 days in the House of Correction. 2005, there's an arrest from Langlade County. Ultimately, he was convicted of a county ordinance violation for disorderly conduct. What's remarkable about that is that he failed to pay the fine, so he was ordered to serve 30 days in jail on the non-payment. 2009 Manitowoc County conviction for obstructing an officer, sentence to 2 days jail, time served. 2010 conviction from Wood County, Wisconsin. He was convicted of the offense of strangulation/suffocation with other charges of battery and criminal damage to property dismissed and read in. The court ordered a withheld sentence for 3 years probation. That probation was revoked, and on August 1 of 2011, he was sentenced to 11 months jail. 2012, he was convicted at the same time on 2 separate files in Milwaukee County. First file was a charge for possession of marijuana as a repeat offender, sentenced to 180 days in the House of Correction. The second file, he was convicted of misdemeanor bail jumping and misdemeanor possession of THC, also sentenced to 180 days in the House of Correction, concurrent to the other case and concurrent to each other. In May of 2012, there was a conviction for resisting obstructing. He was sentenced to 37 days jail consecutive to the earlier sentence imposed in April of that year. He's currently pending on 2 charges in Milwaukee County. 2020 CF 2550, he's charged with 2 counts, second-degree recklessly endangering safety while armed, and 1 count of felon in possession of a firearm. The date of that offense, all 3 offenses, is July 24 of 2020. It's believed he was arrested shortly after that incident and remained in custody in the Milwaukee County Jail until released on bail there for reasons of a speedy trial violation on March 3 of 2021. Bail at that time was lowered from $7,500 cash bail to $500 cash bail. In that case, Your Honor, it is alleged that he got into a fight with his nephew. The defendant fired 1 round from a handgun toward the vehicle that his nephew was in. The vehicle was occupied by another person, and that accounts for the 2 charges of reckless endangering safety. The next day, he was taken into custody, and the residence where he was located, he was found to have a loaded 9mm handgun just a few feet away from him. The handgun was previously reported stolen. Again, he was a convicted felon on that date, so that accounts for the 3rd charge. He's also currently pending in Milwaukee County case number 21 CF 4596. That has a date of offense of November 2, 2021. He's charged there with resisting obstructing, felony bail jumping, second-degree reckless endangering safety in a domestic violence situation, domestic DC, and domestic battery. The allegations in that case, Your Honor, are that he struck the mother of his child in the face with a closed fist. Then as she was walking away from him, he intentionally ran her over with his vehicle. The vehicle in that matter described as what's believed to be the same maroon 2010 Ford Escape used in the allegations in this case. Police went to his home and found him getting out of that Ford Escape. The defendant ignored their commands to stop, and he tried to run into the house before he was apprehended. There's a long history of flight, obstructing, bail jumping type behavior, Your Honor. It's remarkable that these are violations all around the state of Wisconsin, not just his home county of Milwaukee, but we had convictions from Wood County, Manitowoc, and Langlade in northern Wisconsin. I'd like the court to be aware of a record from the state of Nevada. We'll go to Nevada first. That happened, the first conviction was from December 11th of 2006. He was found guilty at trial of a misdemeanor count for obstructing an officer, was sentenced to jail in Nevada. Also on that same day of December 11, 2006, he pled guilty to a domestic battery as a misdemeanor, and the court there ordered a suspended sentence. On March 16th of 2007, he pled guilty to statutory sexual seduction a felony. The court ordered a suspended sentence for 36 months probation. He was also ordered to register on the Nevada Sex Offender Registry. He is currently noted to be non-compliant with that registration requirement. On June 23rd of 2016, he was charged with a sex offender registry violation, first offense. He failed to appear in court, and a warrant remains active for his arrest, so he currently has an outstanding warrant for his arrest in the state of Nevada. In Georgia, Your Honor, the record reflects a May 27, 2021 arrest for misdemeanor battery with a designation of family violence. While it is not clear if he was convicted, he did recently remark to a court official in this county that he had served a 6-month jail sentence in Georgia. So we have not been able to verify if that was a conviction, but certainly there was a confinement in conjunction with that arrest. He has no contact with the criminal justice system in Waukesha County or the district attorney's office. He does have a outstanding paternity case that's been pending since 2003, in which he was adjudicated as the father of a juvenile. And there's been returned court appearances over the years based on failure to pay child support. The court should know that a warrant or capias was issued for Mr. Brooks in this paternity case on at least 8 occasions. He has been sentenced to jail on several prior occasions for failing to pay that child support. And on one occasion, he had his Huber privileges revoked related to one of those jail sentences. That was back in 2009. Most recently, there was a warrant issued for his arrest in that non-support civil case on August 2 of 2021. Judge Maxwell signed an order for him to serve a 120-day jail sentence. Mr. Brooks did make a court appearance in that matter on November 16th of 2021, so just last week, 1 week ago. And he was released at that time because, again, he had explained to the court, provided an explanation that the reason he had not made his child support payments is because he was serving that jail sentence in Georgia. So the court released him that day and ordered him back for a court appearance in the paternity case for December. So, Judge, just based on his prior record, we obviously have very significant concerns about Mr. Brooks' flight history and willingness to obey the orders of the court. But we have to factor in, obviously, the allegations in this case as well. And obviously, I don't need to state Mr. Brooks is facing 5 consecutive life sentences if he's convicted on all counts in this complaint. I wish to notify the court, sadly, that today we learned of another death of a child related to this case. We do expect a 6th count for first-degree intentional homicide to be issued or added, to this case. I can advise the court that I am aware, I've been made aware through investigators that there are other individuals in critical condition. I think we remark on the number of actual injured parties in our complaint. It exceeds 60 people. There's a number of other charges that we are reviewing and considering, but certainly, at the very least, we do intend to file a 6th count of intentional homicide maybe Friday or maybe early next week, depending on when we can accomplish that. Certainly, if we have any other deaths resulting from this incident, additional counts of homicide will be filed. We didn't charge bail jumping. Obviously, we could have. We have focused our efforts to date on the immediate concern, and that involves the loss of life that is alleged to have occurred through the conduct of Mr. Brooks. I want this court to know, and I think the court has read the complaint, you've indicated you've read the complaint, There are not words to describe the risk that this defendant presents to our community. Not only flight risk, but the dangerousness that he presents, his history of violence, and the allegations in this complaint where it is stated plainly that on several occasions he was told to stop by police officers. They risked their own safety to try and step in front of the car to stop him. Everything was done to get him to stop, and he just simply continued down the roadway, causing death and destruction in his path. So I am advocating for a significant cash bail, Your Honor. I'm asking for $5 million cash bail. I know that's a large amount of money, but I think it is warranted on this history, and I think it's warranted when the court considers, if convicted, Mr. Brooks will spend the rest of his life in prison. Thank you.
Thank you. Attorney Perry.
Thank you, Commissioner. When this court determines what amount of monetary bail is reasonable and necessary to assure Mr. Brooks' appearance in court, I guess at today's hearing, the only thing I would add for the court's consideration is that Mr. Brooks is financially indigent, does qualify for public defender representation, and that individual circumstance must be taken into account.
Does that conclude your argument?
It does.
Thank you, sir. So, first of all, let's get to conditions of bail. The monetary portion is called bail. There are conditions, though, in bail. And first, I am going to order, sir, level 4 monitoring through WCS if you do post bail. You're not to leave the confines of the state of Wisconsin. You are only to be released on a business day during business hours. This is the highest ranking sheriff, deputy sheriff. I would like your opinion. I would like the Sheriff's Department to notify WCS if he bails out, that he's to immediately go over to WCS. So would it be asking too much if I had somebody from the Sheriff's Department contact during regular business hours WCS to let them know that he's being released? Then I'm ordering then that the Sheriff's Department contact immediately upon Mr. Brooks walking out the door, if that should happen, that he's on his way to WCS, which is literally a block away. If that does not happen, I want to make sure that people are aware that he did not get on the GPS monitoring device, which I am ordering. I'm ordering him to pay for that as well. Again, he's only to be released on a business day during business hours, with the Sheriff's Department agreeing to contact WCS. If WCS does not have Mr. Brooks come in with a matter of minutes, I would like them, I'm ordering them to then contact the Sheriff's Department of that. I am ordering, sir, that you not operate a motor vehicle. You may not possess any dangerous weapons or firearms. You are not to have contact with the families listed in the victim identification sheet. You are to only disseminate that information to your lawyers. Those are all the conditions of bail. If you violate any condition of bail, including failing to return to court, separate bail jumping charges could be issued against you. In reviewing 969.01 of the Wisconsin statutes and 969.001 that talk about bail and release, the statute reads that there should be reasonable conditions designated to assure his or her appearance in court, Mr. Brooks, protect members of the community from serious bodily harm. And those are the conditions that I just laid out. The bail may be imposed at or after the initial appearance. There should be a reasonable basis to believe that bail is necessary to assure appearance in court. Some of the things to be considered by the court with the conditions of bail are the number and gravity of the offenses, the potential penalty the defendant faces, whether or not the allegations are violent in nature, the prior record of the defendant, character and strength of the evidence which has been presented to the court, whether the defendant is already on bail or subject to other release conditions in other pending cases, and whether or not there's any violations of those release conditions. In reviewing the criminal complaint, the allegations are such that I read that 2 detectives opined that this was an intentional act, that the vehicle seemed to swerve into individuals, actually at one point trying to avoid other vehicles, that the detectives, they're listed as Detective Casey and Detective Chusoni, who again opined that the actions they observed, in their opinion, were intentional. We now have 5. Attorney Opper informed us of a 6th, but that's not here before us today. 5 people that are deceased. We have a gentleman that has a huge background via multiple states. Just going through some of the Wisconsin cases, they're violent. We have substantial battery, DC, strangulation, suffocation, resisting. Pending cases, which the statute I just read references that I should consider: second degree reckless endangering safety while armed, felon in possession of a firearm. Attorney Opper told me that the gun apparently was a stolen handgun. Those are allegations. He's out on bail on that. Also out on bail on the Milwaukee case ending 4596, where he's charged with second-degree reckless endangering safety, disorderly conduct and battery, and resisting. And then we get into Nevada: battery, domestic violence, the sexual assault, the sex offender registration violation, and then the battery in Georgia. Other considerations are, on WCS, their report indicates level 4 monitoring, which is the highest level of monitoring that we have. And in that report, it does indicate there have been failures to appear other than 2 years old, and then sentenced to incarceration prior, yes. Current violent felony, yes, or offense, yes. Pending charges at the time of this offense, yes. Prior misdemeanor convictions, yes. Prior felony convictions, yes. Prior violent conduct or conviction, yes. Prior violent convictions, 3 or more. So there have been missed court dates, although none in the past 2 years, but then we just heard about a rather significant duration of a 6-month stay in Georgia, in custody there. In the recitation by Attorney Opper, we have things that causes the court some cause for concern. Resisting, again, these are things that would cause me to feel that this gentleman does not follow rules very well. Orders of the court, orders of society, resisting an officer. There's a bail jump in 2012. There's a bail jump charged in the 4596 case. There is in the 2550 case, again, the felon in possession of a firearm. All those things are just societal, legal issues, also orders of the court in some instances that are not being followed. While out on bail on 2 rather significant allegations, we are now faced with 5 counts of first-degree intentional homicide. So when I look at that, I look at the gravity of the offenses, the maximum possible penalties as the statute allows for, likelihood of incarceration, which if you're found guilty of 1 or more of these, even 1 would put you in prison for the rest of your life. I believe you are a flight risk. There's failure to follow court orders. This allegation, although the motive is not known, and I'm not entitled to know what that is, but it looks like there was either panic or whatever, or an intentional act for whatever reason. You don't do well under pressure. The Milwaukee County case talks about, as Attorney Opper indicated, you using a vehicle to run over another person with your vehicle. So you don't respond well to what is common sense within our community, our society. So based on that, you're out on bail. Those smallish bails that you were out on didn't do very well. Before I forget, there is Marcy's Law. I understand that although there are, the statute in the Constitution now defines deceased victims to allow for family members to speak. So Attorney Opper, I was told that nobody wishes to speak. We have a number of people from the families. And is that still your understanding?
I'll just confirm that, Your Honor.
Thank you.
Yes, I'm getting confirmation. Nobody wishes to speak to the court at this time, but thank you for your
I have one on your
inquiry.
right. So, ma'am,
I'm sorry.
I would ask that the victim witness individual from the DA's office see who this is without divulging who it is and what relation to what victim she is.
Let's have Carrie report back to us. Yeah, go talk to Carrie before she talks to the court.
Thank you. Sheriff's Department for a warrant. While that is being discussed, I neglected to order DNA be taken. A sample of your DNA, sir, has not been taken. I am ordering that now. It may be expunged if you meet the criterion under the Wisconsin statute. Attorney Basie, where are we?
We're fine to proceed. She does not wish to make a statement.
Okay. Thank you for checking. Thank you, ma'am. The family is always welcome. You do, under the law of the state of Wisconsin, as well as under the amended Constitution, have the right to speak at proceedings germane to the particular proceedings that we're at. So with that, I will set bail. I have no problem with the bail being recommended by the state. I'm an old guy who has been doing this for almost 40 years. DA's office, criminal defense attorney, 17, 18 years as a commissioner, both in Milwaukee and now in Waukesha. The nature of this offense is shocking. Actually, the detail I was not expecting here today, that two detectives, not lay people, detectives, not only tried to stop this, but rendered an opinion that this was an intentional act. You're presumed innocent, sir, but that's what the allegations are. And I've not seen anything like this in my very long career. It seems to be a very strong case for the state. Likelihood of incarceration, which is the other aspect of bail, is absolute. If you are found guilty of any one of these, a multitude of them, it's a life imprisonment sentence that must be meted out. So I have no problem. I just, with that bail, it's extraordinarily high, but it's an extraordinarily big case. It's an extraordinarily serious case with an extraordinary history of this gentleman, of fleeing, of hurting people, of not following court orders, not following criminal laws, not following just your societal norms. So I know that that's extraordinarily high bail. It's warranted here, and I am setting cash bail in the amount of $5 million. And with that, we're going to select a preliminary hearing date. Attorney Perry, time limits?
Commissioner, we would be waiving time limits. We did, off the record, talk with the clerk prior to this and preliminarily set a date for January 14th at 9:15.
What day of the week is it? Okay. Is that a Friday?
It is.
Okay.
Yep, so that date, January 14th at 9:15.
Does that work for the state?
So, Judge, it works for my calendar and Attorney Baizey's calendar. We would ask for an opportunity to confer with any victims that wish to attend. Obviously, that cannot be done with haste here this afternoon. So if we could perhaps just notify the court by Monday if we have any significant challenges. I think if the court can anticipate the ability of live streaming the event, that may assist with some scheduling conflicts as well. But I'm available, Attorney Baizey's available, Detective Casey is available. So yes, that is our request for that date, Your Honor.
Okay, why don't we take that date, and then we can work out the details as far as live stream or otherwise. We'll talk to Madam Clerk, Monica Paz, and see what we could do. So with that, anything else, Attorney Opper?
No, sir, thank you.
And Attorney Perry, anything further?
No, nothing else.
All right, very good. We can be adjourned. So I do want to commend the audience. I know this is very highly emotional. I want to commend the defense for doing a fine job, as well as Attorney Opper and Attorney Baizey. So folks, I know this was very difficult. You handled yourself very, very well. I would ask that you continue on in that vein. If you do choose to come to future court dates, you're always welcome back. I do appreciate how you all handled yourself today, so thank you very much.
Thank you, Commissioner.